and welcome back. If you could take your seats, that would be wonderful. We're going to start our third panel. The only people who shouldn't take their seats are those who want CLE and didn't sign in, because now is the time to do that before the program starts. And I will just say a reminder now to sign out after this panel. Also, there is a reception following the event. That will be in the 7th floor. Go left at the elevators, go up to the elevators, go up to 7 on the elevators, turn left, and you will be at Case Lounge, where our reception will be held, and we look forward to seeing you there. But I know that many of you came for our big ticket item here, so I'm going to sit down and shut up now. Take care.
Thank you, Pippa, and thank you for organizing this event, and thank you to the fantastic panelists that we had this morning. And it's wonderful to see so many of you are former students, to see so many of you here. So this panel features Judge Margaret McKeown of the Ninth Circuit and Judge Pierre Leval of the Second Circuit, well known, I imagine, to all of you. So we're going to just address a series of questions. So they're not going to make prepared speeches, remarks, but I'm going to ask them questions, and then we should have some time at the end for your questions. So starting with Judge Leval, after Campbell and Acuff rose, some lower courts latched on to new meaning or message, taking it out of context to excuse as fair use almost any use that added something new to the copied material or changed its context, thereby setting up the tension between the derivative works right and fair use. But over time, as you predicted, appellate courts looked somewhat more critically at what is meant by a transformative use, and it seemed as if the pendulum, if it had kind of swung way out, was coming back. Under those circumstances, do you think the court should have taken the Warhol case, especially having limited its inquiry to the first factor? So let me start with you, and then I'll ask Judge McKeown for her views on the same question.
It's not as if this is... It's not as if this is extemporizing. These questions, we looked them over before, and we discussed what the questions would be, but you've departed from the text. No, you left off the last line, which is, what difference do you think the Warhol decision will make?
Fair enough.
And that's where I'm prepared to start my answer to a part of the question that you never asked. So, I think the Warhol decision, as I see it, the majority's decision is broken up into two parts. And the first part is the part that essentially consists of a locking of horns with a rebuttal of a locking of horns and overpowering by virtue of having 7 votes to 2 of Justice Kagan's dissenting opinion. And the second part is the part in which the majority concludes that the use by the Warhol Foundation is not a fair use. And I think there are very strange things, particularly about the second part of the opinion. The first part, I think, is very, very faithful to prior Supreme Court authority, particularly the Warhol case. And in that regard, and with respect to its treatment of the Oracle against Google case, I think that the opinion is very respectful and stays within the scope of prior Supreme Court authority pretty generally. I mean, at least doesn't depart from it in a way that contradicts it in any way. And I think that part will have very great effect on the understanding of the fair use law. As to the second part, I don't think it will have an awful lot of effect. So to understand the first part, I think we have to go through three events and consider three events in their sequential order. And the first event is the Campbell against Acuff-Rose case. And Campbell against Acuff-Rose set forth two requirements, two important requirements for satisfying the first factor for achieving fair use. And the first one was transformativeness, and the second one was justification for copying. And it's not entirely clear whether the second one is a separate factor or whether it's a means of whether it's an interpretation of what transformativeness should mean. But in any case, it's intellectually separable concept. And the court called this a targeting requirement. And it said about justification that if the second one criticizes or comments on or sheds light on the original, and by implication, or if it's in some sense about the original, then that's part of what it goes to establishing justification for the copying. And the court went on to say, if it does not shed light on the original, the claim to fairness in borrowing from another's work diminishes accordingly if it does not vanish. And the court called that the targeting requirement. Now, the interesting thing about this was that second requirement at the time went practically unnoticed. And I think the reason that it went kind of unnoticed was that it was couched, as this was a parody case, it was couched in terms of the difference between parody and satire. And so people reading it generally thought, well, that's about parody and satire. Most of the cases are not about parody and satire, so we don't really have to think about that much. Actually, it was about justification for the copying, not just about parody and satire. But it kind of went unnoticed for a while, and as Jane said in the part of the question that she did read, that there was a tendency among a lot of courts, if they found something that they thought was transformativeness, there were changes, some courts regarded that, I think it was mostly district courts. I don't think there were too many Court of Appeals opinions in which that was true. But there was a tendency to give an awful lot of weight to the simple fact that there was something that you could call a transformation. But that would change especially with the arrival of the Warhol case and its resolution in the Supreme Court. Event number two was Google versus Oracle. Now, Campbell, of course, as I just said, had talked about the importance of justification, and that justification would normally consist of some kind of commentary or something that makes it about the work that is copied. Well, Google v. Oracle came along, and it found fair use in something in which there was no commentary, no reflection on the original. It was just taking the original for purposes of making convenient uses of it that would be efficacious. But of course, when it's software by its nature doesn't comment. Software doesn't talk about things. It's a tool. And a very important part of Justice Breyer's opinion in the Google case is to talk about the fact that software is different. He says it again and again and again. And he quotes the work of a famous judge, my dear friend, and I think one of the greatest judges in the federal courts in recent times, Judge Boudin, who said that applying copyright law to computer programs is like assembling a jigsaw puzzle whose pieces don't quite fit. And at the end of the opinion, before I get to the end of the opinion, the different nature of software was so significant that Justice Breyer's opinion took this almost unheard of step of giving great importance to factor two. Nobody's ever given great importance to factor two until this case, when he said, well, when you're dealing with software, that gives great significance to factor two and made it a strong factor in making the determination. And coming to the end of the opinion, he summed up saying, the fact that computer programs are primarily functional makes it difficult to apply traditional copyright concepts in that technological world. In doing so here, we have not changed the nature of those concepts. We do not overturn or modify our earlier cases involving fair use. So the message of that Google v. Oracle case was, this taking of software was a fair use, but software is different. The normal rules of copyright don't apply and cannot apply to it. So event number 3 is the Warhol case. And at least as this first part of the Warhol case is best understood by focusing on the majority's rejection of the dissent. Now, the dissent relied heavily on its reading, its very personal and not, in my view, warranted reading of Campbell and Google. Justice Kagan, acknowledging that Warhol did not comment on or shed light on the Goldsmith original, but that didn't matter in her view, in view of Warhol's what she deemed Warhol's very muscular changes to the original Goldsmith photograph. But as for Campbell's insistence on a justification in the nature of shedding light on the original, the dissent barely mentions it, and she just makes a very casual reference to the so-called targeting requirement, and she mentions it really only to say that the Campbell opinion acknowledged that there could be exceptions, which it did. The Campbell opinion did not present it as an absolute requirement, but something to which there could be exceptions. But that's all she had to say about that, was that Campbell said there could be exceptions. And the dissent invoked the Google case, where fair use was found without targeting. The dissent interpreted as meaning that the Google case had essentially written out of the law Campbell's insistence on the importance of targeting and of commenting on, criticizing, or in some sense being about the original work. So the majority unequivocally rejected the dissent's interpretations of those two cases. The majority opinion in Warhol goes to great lengths, quoting verbatim at length the language from Campbell that talked about when there is no reflection on the original, the justification for the copying is diminished if it does not altogether vanish. And then when it came to the interpretation of Google v. Oracle, it did, as Justice Kagan suggested, did Google v. Oracle essentially do away with the targeting requirement. Justice Sotomayor made a point of referring to the fact that the Supreme Court noted that software was different, and so draws the conclusion that we cannot treat the Google v. Oracle case as having read the targeting requirement out of the Campbell case. So there had been a great deal of debate in the world of consideration of fair use as to what is to be done with works of art that take somebody else's work of art and then use it to make a different work of art that don't comment on the original, but that are using the original work as raw material, or just using it in some way to create a new work of art, which is the work of the second user and has nothing really to do with the first except that it uses it. And I think one can only treat the Warhol opinion as settling the proposition that that is not a use that favors fair use. That is a negative with respect to assessing the first factor, and very likely will be determinative as to whether the thing is found to be a fair use. The majority said about Google that about the dissent's reading of Google that the dissent simply didn't read the opinion as a whole. So I think we inferior courts are no longer at liberty to disregard the need for justification in copying. So that's it for my first.
Well, Judge McKeown, you want to elaborate further?
Sure. Well, thank you. Thanks to Columbia Law School for inviting me here. I agree with Judge Leval that the starting point for all this is Campbell. And one of the mysteries is, well, we had Campbell, which was pretty clear. Why do we even need Warhol? Well, there's a reason. You remember back, of course, Campbell was a parody case. And there were some who thought Campbell was limited to parody, which it clearly was not. If you look at all the cases since Campbell, less than 20% actually involved parody. So what you had is the district courts and the circuit courts were basically off and running on what does Campbell mean, and really it was all focused on what does transformative mean. I hope we now have a little more nuance and texture on that, because we've been debating that for a number of years now. And it came to be that really any new meaning or any additional aesthetics all of a sudden were transformed into transformative, and that of course couldn't be right. I like to think that the Ninth Circuit and the Second Circuit brought a little bit more of guardrails to all of this. In the Ninth Circuit, we have about 40% of the U.S. copyright docket, and then a significant amount, of course, is here in New York in the Second Circuit. So the question is, well, should the court, Jane's question, have taken the case because it was limited to the first factor? Well, my answer is absolutely. I'm delighted that the court took the case. We've seen a lot of academic articles belittling fair use, saying it's billowing goo and acting as if there are no guardrails, which isn't really true. But the truth is that courts were and have been all over the map on fair use. So go back and read a lot of these decisions, and then you say to yourself, well, can I bring a principle from all these decisions? Not necessarily, and it might depend on what circuit you're in. The Seventh Circuit criticized Carreau, and courts have struggled, well, how do you analyze fair use? And of course, a lot of this, as we know, the hard work is done in the district court, because that's where the facts are on the table, and that's where the cases are first presented. So I went back to look at the district court opinion in Warhol, and the court there found that Warhol's art was of a very different character because it brought new aesthetics and it gave the photo new expression. So I would say, well, that was exhibit one for why it was important for the court to take the case, because they wanted to bring us back to first principles, to the justification and the targeting that we first saw in Campbell. So as we look at it, and you look at cases over the years, most often the first factor focused on transformativeness. And if the court found that something was transformative, it almost seemed like the other factors just fell onto the table. On the other hand, if they found that it was not transformative, then of course the fair use would be eclipsed. And that's not right either. So that was really one of the difficulties in looking back over all these opinions. And I think that the good thing about Warhol is it gives us both context and language to invoke under the first factor. We now have a purpose-driven inquiry And it channels our discussion in a different way than we've had over the years, but in a way that I think is quite clear. So you might say, well, I thought Campbell did that. And Campbell did, but apparently it didn't do it strongly enough, because here we are and we needed Warhol. So transformation in that language, I think, has really muddied the waters, and we now have clear language from the court. As Judge Leval alluded to, if a commentary doesn't have any critical bearing on the substance or style, then that kind of fair use diminishes. And also, you see a lot of language in both circuit, district court cases over time that says, let's look at what new expression is there. One of the things I think the Supreme Court has been most helpful in its language is saying that new expression may be relevant to whether copying use has a sufficiently distinct purpose or character. But without more, it's not dispositive. Whereas in some of the cases over time, this new expression has become dispositive. So I do think we now have some new guidelines, or at least more explicit guidelines, for the lower courts to use. Let me comment also, as Judge Leval did, on Google v. Oracle. I kind of view Google v. Oracle as the Bush v. Gore of the copyright. Why? Okay. Remember in Bush v. Gore, the court said, our consideration is limited to the present circumstances for the problem of equal protection in elections processes generally presents many complexities. Well, that's certainly true of fair use and copyright. There's many complexities. But you know, the focus in Google v. Oracle was on the Java programming and the use of the APIs, the application program interfaces. So even though there is not such an unequivocal statement like we had in Bush v. Gore, it seems to me that the court almost made the same statement in different language. And the court talked about rapidly changing technological, economic, and business-related circumstances. And they even commented there in Google v. Oracle on the fourth factor and public benefits, posing some questions, which they didn't answer but say they could be of interest down the road. So I think that there's not a lot to be mined from Google and Oracle, other than how Justice Sotomayor and her majority laid it out, that it was talking about something very different. It was talking about software. And obviously, software is not always the same as some of the other literary and other types of work that are presented under copyright. I also thought that it was interesting with respect to the dissent in Google v. Oracle. Justice Thomas said, computer code occupies a unique space in intellectual property. And I think he agreed with the majority on that point, at least, because the majority had said, when you're looking at computer code, you're almost always looking at something that's functional. So there didn't need to be much of a debate in Warhol between the majority and the dissent on Google v. Oracle, but there was, and I think that the majority pretty well closes the story on that. So in short answer to your question, for those of us who have to figure out what fair use is once it's gone through the trial court, I think that it's a good thing that the court took the Warhol case. We hadn't had a case quite like that in many years. And also, I think it gave the court an opportunity to lay to rest some of the misconceptions that we've seen floating around about transformativeness. And as someone said earlier, well, works aren't transformative, it's uses that are transformative. So we have a slightly altered lexicon and language that we can use. And if we didn't have the Warhol opinion, we wouldn't have this seminar. So
I'm inclined to think that that Google v. Oracle will have a little bit longer tail, viewing it as a precedent in which the Supreme Court has said that that there can be a transformative use, a use that would satisfy the first factor, that would be a fair use, without in any way commenting, without commenting on the original or shedding light on the original, but that would be something that doesn't in any way invalidate or cabin or lessen the force of what was said in Campbell about the need for such targeting. I think that there's going to be, particularly thinking about AI, there's going to be a whole range of cases, and there already have been some. One of which I think I had. The secondary use in the Google Books case, when Google copied these millions and millions of books into a database. Now, the first use of it was a use which, in my view, did conform to the targeting requirement, because it was to enable a user of Google Books to go to a particular book, which is the one that claims to, each book is the one that claims to have been infringed by the taking of it, and the user could go into the program and find out certain facts about that book, like snippets and how often it uses certain words, and the snippets that give a sense of how it treats the word that the person is looking for, to help the person decide whether that's a book that she wants to read. But then the secondary use was called the engram use, where all that material was ingested into the computer system for the purpose of producing a kind of a graph that showed over the last 100 years, decade by decade, things about word usage, such as when the United States was referred to in the plural, United States are, and the change to United States is, all kinds of uses like that. And that is not in any way commenting on the particular book. It's not even about the book that the plaintiff is talking about. So particularly when we go into the era of AI, we're already there. And what happens in AI is that the computers ingest gargantuan amounts of material, much of which is under copyright, for the purpose of producing all kinds of information that has nothing to do, particularly, that in some cases will have little to do with the particular work that was copied. I think that's going to be another area that will reflect the Oracle versus Google decision, that you can have you can have a taking that can favor the taker under fair use without targeting. So I think it's going to have a further tail.
Obviously, that's an extraordinarily contentious topic. As for the cabining of Oracle and Google, Justice Thomas also suggested that the court had produced an opinion for declaring code only, so not even just for software, although he, of course, was in dissent. The court did emphasize many times that the subject matter was far from the core of copyright. With AI, AI ingests works that are squarely in the core of copyright. So what it does with them is a separate question, but as to what is the subject matter at issue, I think that there is a significant difference between Google and Oracle and the passel of pending AI cases. So I guess that it remains to be seen how much of a long tail Google and Oracle has, whether it can in fact be confined to subject matter far from the core of copyright, this functional interoperable software. But now that we've gone off script, actually, Judge Leval also anticipated a question that I was going to ask later, but let me ask it of Margaret, of Judge McKeown now, which is the raw material defense. Judge Leval suggested that the raw material defense may not carry the day in the way that it has in the past if it's not accompanied by some kind of justification other than I'm an artist and I'm using other people's stuff. So what do you think, the Warhol case tells us about the raw material defense?
Well, we know that there are a number of cases that have upheld a defendant's use of raw materials as fair use, even if there's no critical comment or reference to the original. As I read the majority in Warhol, it didn't reference the raw material issue directly. The dissent did, so I guess that's what prompts the question. But I don't see how the majority would make raw material irrelevant in and of itself. You'd need to look again at what's the purpose and character. So obviously, just because I used raw material makes it fair use, that can't fly. But if, and in a way, the raw material is like this Mobius strip. You just keep folding yourself back on itself as you talk about raw material. But I think that courts do need to be cautious about the old admonition that courts are not art critics, and I know we probably will talk about that when we're talking about raw materials. There's a couple of cases, and I think of one in the Ninth Circuit earlier, citing Campbell, Seltzer v. Green Day, and it was a concert video, and it used a photo of some street art in the concert video. Sometimes it was called a scream icon. But when they did the concert video, there was commentary of the concert video, or the idea of it had to do with religion and Christianity and a defaced Jesus, which really had nothing to do with the photo one might have taken off of the street art. The court cited Campbell and said that the video was for a different purpose and was transformative. But I think the important thing there is it's not like the analysis ended on the first factor. The court then marched through to see how did it fit within the overall video, what was the commerciality, and in terms of market substitution, and that sort of thing. Now, with the benefit of Warhol, I think the language might have been slightly differently nuanced, but it's not clear that the outcome would have been different. So it seems to me that raw material is just one aspect of a challenged work. And one thing, we get sunk in the Warhol decision because it's only factor one, and we kind of forget that we have all these other factors that we're supposed to be considering. And I think very few courts are going to hang their hat on just factor one. One, because they don't want to get reversed, and two, because in fairness to the arguments, there's more to fair use than just factor one. So it certainly could be that factor one could weigh against fair use, for example, but it's an insubstantial use, or the market isn't impacted, or there's other factors. So while Warhol telescopes this whole conference into factor one, I don't want to forget the other three.
That's exactly the question I was going to ask, which is, I'll ask Judge Leval, how do you think lower courts are going to sort out the remaining factors, especially given the criticism voiced by Justice Kagan that the majority collapsed the first and the fourth factors? Justice Gorsuch says no, it's the first factor inquires what is the purpose, and the fourth factor inquires what is the effect, and that's how you can keep them straight. Do you think that in practice it will be, how workable will it be to keep them straight?
Well, they necessarily have some overlap. How the secondary user has used the first and what effect it had on the market are two different questions, but they both can involve the likelihood of superseding, the likelihood if the copying work is perceived as one that's intended to offer itself as superseding, possibly superseding competition with the first, that is perfectly proper consideration to be included in the first factor, and it will also be considered in the fourth factor. If the events haven't occurred yet, it will be assessed in the fourth factor as what's likely to happen to the value of the copyright if this proceeds further. If it has happened already, there'll be an assessment of what effect it has had on the value of the original user's copyright. But I agree with that part of Judge Gorsuch's opinion. I mean, there are a lot of confusing things about the Warhol decision, but it didn't suggest that the other factors are irrelevant. It concluded, if I recall, by saying something to the effect that the others have been sorted out below, and the only one that was in question before us is the first factor, so that's the one we're talking about, but we're certainly not saying that the others don't have an important effect. Indeed, at times the Supreme Court has called the fourth by far the most important. It certainly is important, whether it's the most or not, as angels on the head of a pin.
So neither of you think that the court taking cert only on the first factor will have the effect of continuing the outsized importance that the first factor has received up till now?
No, I don't think so. If you go to the end of the Warhol opinion, the court says the four statutory fair use factors may not be treated in isolation, one from another. So that does get obscured in the first 38 pages. Because that's the only thing the court is talking about. But I do think, as Judge Leval said, it's important to look at the Gorsuch concurrence, because I think that will be useful just in thinking about statutory interpretation. So it does add something to the opinion. But in my view, the court didn't say anything about its precedent that the fourth factor has been deemed the most important. Obviously, there's a relationship between commercialism in factor one and the market effect or potential market value in factor four. But I think you'll continue to see courts go to prior precedent and say, Warhol said nothing about factor four. It did not collapse 1 and 4 despite the dissent's suggestion to that. So I think you'll continue to see courts focusing on factor four, and that's because you can have, I think you can lose potentially under factor one, but with all of the other factors, you could potentially win in this whole constellation of fair use. And the question of market analysis, it's a case-by-case determination. So I don't think it's in any event answered up front by the commercialism aspect of factor one. And in the prior panel, it was mentioned that now this commercialism has been heightened to a degree, but it is a matter of degree. And it's not like a yes or no, it's not like some binary decision, oh, it's commercial, therefore. It is a question of degree, because there's commercial and there's commercial.
I do think in answer to your question that there is some likelihood of misunderstanding in the lower courts. I think it happens all the time that the Supreme Court talks about the issue that's before it, and then people give outsized importance to what the Supreme Court said there. It's not unusual, but it's not good judging. Litigants will try to use it to their advantage, to give more importance to it if it favors them. And sometimes that bamboozles courts, but it usually straightens itself out in the end. I mean, I think it's sufficiently clear, as Margaret was saying, that the other factors weren't being pushed out the door. They just weren't the ones that were involved in this case. So I trust over time judges will understand that.
I mean, I think the reason they weren't involved is they weren't challenged, they weren't before the court in the Supreme Court. So you had these other three factors that were not factors. So I agree that, it's not often we get a big copyright decision. So everybody's trying to, means something for everyone. And there will be a lot of lawyers trying to read things into it. And I remember being a lawyer and trying to kind of shake and squeeze language out of Supreme Court and Circuit Court decisions to try to see what they meant. And we'll see a lot of that. But I think you have to have some faith that both the trial court and the circuit courts will try to see the opinion for what it is. It's not the be-all and end-all of copyright law, but it sure does go a long way in giving us a little clearer language, I think, in which to benchmark the decisions.
After Warhol, as was already said a couple times this morning, it seems that there are three elements to assessing the first factor. One is the purpose of the defendant's, let us say the second author's use relative to the first author's actual or potential exploitation of the work. The second, which we've been discussing, is the commerciality of the second author's exploitation, and the third is the justification, including whether the defendant's work shines light on or is, in at least some sense, about the copied material. So, although Judge Leval, I think, started an answer to this question, I'll return to it, which is, must the second author always have a justification, even in the absence of competing uses? Or is it enough to say, we're operating in completely separate markets, so that's all that matters?
Well, to start, I'm not quite sure whether Jane, whether you are intending to eliminate transformativeness from the surviving factors after the Warhol opinion. You named three: the purpose of the defendant's exploitation relative to the plaintiff's actual or potential exploitation of the work, and commerciality, and the defendant's justification for copying. You didn't say anything about transformative. I certainly don't think that it was the intention of the Warhol majority to exclude transformativeness, to which Campbell gave such importance, from the factors that will survive to be considered in connection with fair use.
I should have clarified that those elements, at least the first and the third, I think those are the elements that the court looked at in determining whether or not the use was transformative.
Okay. Well, yeah, I guess one gets confused with the diction, and it can be confusing. I mean, the majority opinion certainly gave a lot of attention to whether there was what we normally think of as a transformative use. Justice Kagan had made much of the changes that Warhol made, and she had, talked about the shifting of the angle of the head and the printing in high contrast, so that all the modulated shaping disappears, and you only have black and white, and how that had the effect of transforming it from a portrait of a human being with the human being's insecurities and all that to a portrait of then cutting off the neck and shoulders, so it was kind of a balloon floating there, and how this transformed it from a portrait of a human being to a portrait of the celebrity publicization machine. And Kagan gave that tremendous importance as transformative, and the majority opinion kind of says, yes, well, there are these changes. They are indeed there, but they're not really that big a deal in terms of transformativeness. In the end, what you have here is two different largely photographic portraits of the famous singer Prince, and they compete in the same marketplace. So I think those are very definitely all that continues to be. I don't think it changes the perception of the first factor from what it was as perceived by the Campbell opinion. Now, the second part of the opinion, which poses the question whether essentially it turns on the fact that the marketing by the Warhol Foundation of the work to magazines, the same essential potential market that Lynn Goldsmith had for magazine covers, and making that largely determinative of the Supreme Court's decision, and turning attention away from whether Andy Warhol had made a fair use. I thought that was a very curious, this is what I referred to in my first answer, the second part of the opinion, and I think it's very, very odd. I'm not quite sure what the reasons for it were. I think there may have been two reasons. I can imagine the Supreme Court just not wanting to take on the celebrated Andy Warhol, and I can imagine the justices having said in their conference, can't we just lay it on the foundation and not tangle with this icon? Sonia, figure out a way to do it, which she undertook. Or maybe it had something to do with not wanting to tangle with the points that Pam was raising this morning about not wanting to get into the implications for Section 103 and whether the decision would cost Warhol a copyright over his own aspects of the work, the aspects that he created of the work. But it seems to me that it just doesn't work. The case came to being because the foundation sued for a declaratory judgment that the work made by Warhol, which had been licensed to a magazine, was a fair use. Now, if it was a fair use, then it was a fair use and it was not an infringement. And if it was not an infringement, there's no way that if it's not an infringement, then there's no copyright liability. So the Supreme Court couldn't, as I see it, couldn't really get to imposing liability on the Warhol Foundation without coming to the conclusion that if this had been done by Warhol himself, it would not have been a fair use. And the majority comes very close to saying that when it's rebutting Kagan's arguments. So I don't think it really works. I don't understand how one can take this as not having having had any reflection, even if it stopped short of coming out with an outright declaration that Andy Warhol did not make it, that had he been the one who had licensed this to Vanity Fair, it would not have been a fair use. That seems to me to be implicit in the Supreme Court's judgment, even though it says it's not reaching it. A few further words that occurred to me this morning when Pam was discussing the question of Section 103, which is, this case is in a very peculiar posture because while the question whether Andy Warhol, had he been the one who had been still alive and had marketed this to Vanity Fair in exactly the manner that his successor, the foundation, did, that question had enormous importance, it seems to me, for whether the foundation can be liable for the fair use. If the use is a non-infringing use, it's the same use. The foundation made the same use that by hypothesis Andy would have made, licensing it to Vanity Fair for use a second time of one. But while it has importance for that case, it seems to me it would not have had any importance whatsoever for whether Andy Warhol and consequently the foundation owns a copyright in the work. Because when Andy Warhol made the work, he made it under a license. So he did not make it illegally. Assuming this, of course, depends on how you interpret the license. And if you interpret the license, as I think is sensible to do, as not just a license to make a single image, but a license to create a work that will be used one time, but in the course of creation gives the artist the opportunity to do sketches and trial runs, and Warhol did 16 of them. And I think it's a fair interpretation, although apparently not the one initially taken by Goldsmith, but I think it's a fair interpretation to say that in creating those 16 works, Warhol did not commit an infringement of copyright, if only for the reason that he was licensed to make a work of which there would be one usage that would be under the license, and nothing that he did that violated that term, as making the 16 trial runs was not a violation. So I think Warhol would not have fallen. I think Warhol would not have fallen under, and I mean there would be no contention that the making of these works was an infringement of copyright. I don't think it would. I don't think it would have borne on Warhol's use of the 16 works, or on the licensing of the one to the. I don't see how there would be any good argument that there had been taken place 15 violations of Lynn Goldsmith's copyright.
I just add that I think that's why you see all these disclaimers. We can't have a famous artist exception that's talked about. I would just say, with respect to the licensing, to me there's a bit of a morality play going on here, and I kind of read that between the lines. Sort of, you got a license once, could have gotten another license, but you didn't ask. And so that is often the kind of morality issues that often underlie these copyright cases. And the court doesn't come right out and say that, but I certainly see that in the discussion. And of course, we have to read between the lines when we're figuring out, well, what was the first license for? And as Pam said, are we really looking at all of these prints and we're not talking about them? And was the Supreme Court talking about X and the case was about Y? I guess we'll never know. We only know what the decision is appended to, which is basically the single license, the orange prints.
just picking up on morality play, and this relates to Eva's photographers. The Supreme Court, in 5 different places in the Warhol opinion, alluded to Lynn Goldsmith's getting or not getting credit. Right? They didn't then draw out further implications from that. Or does that mean that it's not so fair if Lynn Goldsmith, having got credit the first time, didn't get credit the second time? Credit seems to be extremely important, both as Eva and as Professor Matima indicated. That's often what creators really care about. Do you think that credit should be taken into account? I know this was not one of the questions we pre-discussed, but since we opened it up, do you think that credit should be taken into account in a fair use evaluation? Not simply mentioned, but actually figuring in the analysis?
Well, it seems to me to be a real double-edged sword. You say, well, the artist gave credit and then ripped off the work. I don't know, as Professor Latima said, if that really gives you a lot of solace. Or you could say, well, they never gave credit and then did what they did. So that's also bad. So I'm not sure that credit, other than as a factual backdrop, really fits into the criteria that the Supreme Court has laid out. But I don't want to preclude it or preclude any argument, because there may be some good bases for that. But I do see that credit thing as a double-edged sword.
I also see it as a red herring, because it's not really what the copyright law is about. Judges tend to write opinion in which they put emphasis on facts that make their decision look good, even when those facts are irrelevant. I mean, you see this all the time in horrible murder cases where the facts of the case really have nothing to do with the issue, which might be whether a court correctly interpreted some sentencing provision to allow something or not allow it, and when the majority of the persons writing the court decision are coming to the conclusion that the court erred in not giving a more severe sentence, in thinking that it was prohibited from doing so for reasons having nothing to do with the facts of the offense, but just with the meaning of the statute, they will write an opinion which at length they talk about how bloody and gory and horrible the murder was, when it's totally irrelevant. And I think there's a little bit of that here with the credit. An infringement doesn't become less of an infringement because credit is given, nor is it more of an infringement because credit is not given. So I don't think it really matters, but it tends to affect persuasiveness.
Flavor.
I mean, I'm not sure we'd all agree that credit is merely a matter of atmospherics. But moving on to the questions we agreed to talk about, this one is for Judge Leval. The dissent's analysis is arguably at odds with Justice Holmes' warning that judges should not make decisions of law based on the judge's assessments of artistic quality. If Justice Kagan's opinion had been the majority opinion, how would this affect the future development of the law for cases of similar appropriation?
Yeah, I think that was quite an important issue in the case. Justice Kagan was extraordinarily contemptuous of the majority. I mean, she showed her enormous sophistication in understanding and being well educated in matters of art and literature and painting, and knowing the origins of the Romeo and Juliet story, and tracing lines of painters using the same theme from Giorgione to Titian to Manet and so forth, and expressing contempt. And then with respect to her contention of the great genius of Warhol, expressing contempt for the majority for not being alert to this, and what's worse, seeming to have no interest in it. The majority was only interested in the question of law. But more to the point of your question, it's easy enough when the person who's found to be at fault for having infringed fair use is a universally recognized famous artist, treated as kind of a genius, very widely so. And it's easy enough to say that this is a great artist. He must have been making great art. Great artists make great art, and people who aren't great artists don't. Justice Kagan also had a line in the opinion that was kind of dismissive, I thought very unfairly so, of the plaintiff in Goldsmith. There was a line that said something to the effect of, "Why would anybody be interested in any event?" Easy as it is to say that a famous artist has done what should be recognized as great art, what happens in the next case when the person who has done what Warhol did, and I don't mean with the license, but the person who has taken another work to make a successive work of art, when the taker is an unknown, which is very frequently the case. Given Justice Holmes's admonition, don't be, you're judges, you're not art critics. Don't be out there making your judgment as to whether something has artistic merit or not. Are judges going to say, well, I'm coming to the conclusion that this use of the plaintiff's work had no artistic value, had no importance, nothing of value in the changes made, nothing of value of artistic value or social value. I don't think judges would do that. I think that if Kagan's if Kagan's position had been the majority position, so this was now the law, you would now have essentially the situation would be that that one can take any artist can take any other artist's work, and as long as they make some changes that they can argue were transformative changes, that all of that will pass. Now, whether that's a good thing or a bad thing is perhaps open to disagreement, but I think it would be an enormous change from what the law is now.
Mr. McKeown?
Oh, I'll just add that over the years, you can go through many opinions, and many judges have invoked Holmes' admonition and then gone on to be an art critic. And it may be that because some of the language used in the past was like, is it a new expression? Well, we now have some limitations on that, so it remains to be seen whether judges will talk about the art critic world as a way of background, but not necessarily by way of judgment, and whether Warhol will cabin judges in how they talk about artistic expression. So come back in 10 years and we will see what the impact of Warhol has been.
Well, I think that the emphasis that the majority put on the whether or not the use was transformative, as opposed to whether the work was transformative, may make those explorations of artistic merit less likely, because the Second Circuit, in determining whether or not the use was transformative, did get a little bit into art criticism in making a distinction between having as the subject of the work a single work, so you are doing your artistic thing on only one person's work as opposed to doing your artistic thing on many different or several different artists' work. It's a very bad joke in copyright law that copying from one source is infringement and copying from multiple sources is research. But, and that aspect of the Second Circuit's decision veered a little bit in that direction. The advantage of comparing the uses, right, is this use the same is this exploitation the same kind of exploitation? Then you don't have to examine what the artistic merit or lack of it of the work. Right. Having said that, I'm not sure what we'll see in 10 years is the extent to which courts actually maintain the difference between the transformativeness of the use and the transformativeness of the work. Right. Go ahead.
Well, I mean, I just thought some of the language traded back and forth where the majority said that the dissent's account of fair use is unbalanced in theory and perhaps relatedly in tone. And then, of course, the dissent comes back and says, well, majority plants itself in the I could paint that school of criticism, which brought to my mind when I was practicing law and we had an art historian partner who had purchased some very interesting contemporary art. And as the partners were looking at the price tag of some of this contemporary art, there was a lot of, I could have done that, or my kid could have done that. But I thought it was interesting that there was fairly pointed language between the majority and the dissent on a lot of the points that Jane has asked us about.
Do you want to add anything to this? Okay. All right, so at this point, we have a little more than 15 minutes. So I think we can open it up to all of you for questions. Josh.
Does this work? Is this working now? Does this work now? Yes.
Yes.
So in Google v. Oracle, the Supreme Court went out of its way to talk about the role of the jury, because that was a jury trial, and they said the jury heard this and the jury heard that and made its conclusions based on it. In Warhol, you have a district court judge on summary judgment deciding things one way, Second Circuit, 3 judges going the other way, and now the Supreme Court also dividing. And I'm curious, what do you think the role of the jury is to play in this system? In particular, I note that the 7th Circuit and the 9th Circuit model jury instructions for fair use just are the factors. They're just the factors straight out of the statute with none of the discussion that you've all been having. So I'm curious, what is a jury to do when you say, okay, you come in and decide some of these factual disputes?
Well, I'm a big believer in the jury system, and you see a lot of summary judgments that basically say the historical facts are not in dispute, and therefore summary judgment is appropriate, and here is the decision on summary judgment. But I don't think that courts are inclined to give more texture than the legal factors, and leave that, in cases where there are facts that are in dispute, to leave that to the advocacy of the lawyers and also to the testimony. Because then, as we know, a number of cases are resolved up front on fair use. We don't even know if there's a copyright, something that's copyrightable, or if there's an infringement, because you may be able to be up or out on the fair use decision. So I don't see that this case disturbs that. That wasn't really a focus that was brought to the Second Circuit or then up to the Supreme Court as to whether there should have been a jury trial on all of this. So I don't read anything in here that changes the calculus of how we view this now in terms of whether or not summary judgment is appropriate or whether there's factual disputes that really require a jury trial.
I think that's an unbelievably difficult question for a judge to face. I can only say I was very gratified that I never faced that question as a district judge, because there are so many issues that come up. There are so many moving parts in a fair use decision. And while certainly there might be circumstances, there are circumstances where some of the issues are clearly factual issues that are appropriate to submit to a jury, whether the work was transformative, that question it's hard for me to see how that's a suitable question to give to a jury. I think it's very hard to generalize how a district judge should deal with that in a jury trial. I think it would be desirable for the district judge to design special interrogatories for the jury to isolate questions that clearly called for decisions of fact, and then perhaps leave the rest. I think the district judge should leave itself a good deal of room to override the jury's verdict if the district judge thought that it simply came out wrong, notwithstanding accepting the jury's verdict on the things that clearly were facts. But it's hard to give a simple answer to a question that's really is tremendously complicated. I once had a copyright jury trial that fortunately didn't deal with a fair use issue, but it was kind of interesting. It involved, there was a time in our history about 30, 40 years ago when practically every book written and every movie made was about a sniper in a football stadium, and the writer of one book that had not been published had sent it to a movie studio at a time when the movie studio, like all the other movie studios, had a movie in the works about a sniper in a football stadium. And in order to judge the case, the jury was going to have to read the plaintiff's book and about 6 or 7 different treatments of the movie script. The movie company had the foresight to immediately erect a Chinese wall and keep everybody involved in the movie away from any contact with the book. And what I suggested to counsel, I said, we can only do this if you'll approve. But what I think would be a good idea would be to say to all the jurors, this is going to involve reading a book and 6 book-length scripts, and if that doesn't appeal to you, you can go home. And they thought that was a good idea, so we did that, and 9/10 of the jury pool went home, and the rest of them, then the questions we asked, they were questions that I put to the jury, to the remaining jurors, like tell about your reading habits, and these were people who said 9 books a week, that kind of thing. And and then we also conducted the trial by first having brief opening statements, then send the jury home with all the reading material for a week, and then resume with, again, more opening statements, and then the trial. And the jury had all these written materials in the jury room, and after they rendered their verdict absolutely correctly, I thought, in favor of the defendant movie company, they went home, and my clerk went into the jury room and collected all those books that they left there. And they were about 1,000 little Post-its. Anyway, that doesn't answer your question, but...
On the other hand, if you told them all you have to look at is this photo and the orange prints, they would all be, I can do that. And of course, we've had 200 years of jury trials in fair use cases, so probably have 200 more.
Thank you so much for this really wonderful panel and a genuinely illuminating day. My name is Noam Elcott. I teach art history, modern art history at Columbia. And I have a question around one element that is, I have been following the Warhol trial and various legal issues of late. I'm no lawyer by training. one issue that is front and center in the in 107 in the legislation factors in rather prominently in the background of the Supreme Court case in the actual majority opinion, and especially in the use of images, as I understand it, unlicensed. But never ever gets treatment in any of these discussions, as far as I can tell, and that is fair use of images in scholarship. And as you probably know, or may you
Fair use what?
of images in scholarship. And as I said, as you may know, you likely know, but you actually may very well not know, the rule within art history is that no matter what the reproduction of images for scholarly use, it's effectively never considered fair use. So there's almost no university press that will publish a scholarly book, even when the images are in black and white, of color paintings, even when, I mean, really pretty much almost under any circumstances, without clearing rights. And for an average art historian, that could be for a very famous, tenured, wealthy professor, but also for a graduate student who has nothing, that can run in the thousands of dollars, for which obviously no one is ever receiving, a fraction of that in book royalties. And I wonder, and on some level my question is a very naive one, which is, why is this seemingly huge gap, why does this persist? And then a equally naive question is, what can be done to fix this? As I understand it, among the problems is there's no constituency to raise this issue. No university press is going to go to trial on behalf of some junior professor someplace and risk massive exposure against, say, the Picasso estate or Warhol Foundation with massive financial resources. So it never goes to trial because the university pressers simply won't allow books to advance without having cleared the rights. So effectively, there is no fair use of images within scholarship. And yet, as best I can tell, the Supreme Court has no problem reproducing many copyright images without any permission. So we have something of a quagmire because there seems to be an obvious legal solution, or at least as a matter of law, there seems to be an obvious answer. I may be wrong here. I'd love to be corrected. But there's no way to implement it, as best I can tell. And I was wondering if you have any thoughts or guidance on this issue.
Yeah, well, you raise a very understandable frustration, and I think that if one simply looks at the law as it's established, it's very easy to imagine art historical texts that would make what should absolutely be considered a fair use, because they would conform to all of the factors that have been regarded as important. On the other hand, it's also easy to imagine some art historical publications that would be seen simply as an opportunity to sell a book showing the work of Andy Warhol. The problem, as you say, is that the presses are unwilling to assume the risk. Now, maybe they should be a little more aggressive about efforts to get permission to do so, either on payment of a modest amount of money or even without it. But I think that if people would run the risk, there'd be litigation, and then you'd have some guidelines that would give framework. But it's understandable. If I were running a press, I'd be afraid to do it too. But it's the law has a lot of uncertainties in it. They're very unpredictable, and I can understand why the universities that don't have gigantic budgets are unwilling to run the risk. But there certainly are very strong arguments about that illustration of pictures that are designed to illustrate a critical point about the art history being discussed. It doesn't compete. It doesn't really. Well, I mean, it competes with the derivative market of books, of like coffee table books about this artist's work. the further it gets from that, the easier a road you would have to establishing fair use.
Yeah, I agree with Judge Leval. It's a very, it's a difficult question because, of course, educational use is spelled out in the fair use section. Just two comments with respect to the courts reproducing. These, of course, are reproductions of exhibits submitted to the court by the parties, so presumably with their permission. So we see that. I had a case involving Dr. Seuss and Comic Mix, and we saw a lot of the various images reproduced, and it brings to mind a case I had involving Catalogue Raisonné for Picasso, and the collision between European standards and U.S. fair use standards. In that particular case, we said that the European standards couldn't trump a U.S. fair use standard, so the case went back to its resolution. But we have seen cases like this, and we have seen university presses and of course in the early days the libraries getting sued because of, and universities getting sued because of students, copying some piece of paper. So, there are cases, there are precedent, but you raised the real practical problem is what are the economics of this? And perhaps that can be another seminar for your center to take a look at.
Well, I think Justice Gorsuch actually mentioned scholarly publishing
Yes.
as an example of a use that might be fair. And the court did say that with respect to the same work by the defendant, some uses might be fair and others might not be. The court did not then spell out, the majority did not spell out which is which, but there are some suggestions in Justice Gorsuch's opinion. You would want to say something about commerciality?
Yes, I was prompted listening to the discussion this morning of commerciality to suggest a kind of a critique of how the subject of commerciality has been treated, which is that one tends to refer to the issue as the commerciality issue, and doing it that way. When what the statute says is including the purpose and character of the use, including whether it is commercial or nonprofit educational use. I think it would be a little less misleading, rather than calling it the commerciality issue, to call it but this would take a longer time and be a nuisance and a pain, to call it the issue of commerciality as opposed to nonprofit educational use. But my point is that especially when you look at the prefatory examples that you look at, an awful lot of them, and awful lot of the things that are most widely accepted as fair uses are commercial uses. Newspapers, textbooks, and history books, and things like that. When a newspaper publishes the remarks of a politician, that's commercial. Book reviews are published by newspapers, which is commercial. And it seems to me that the issue would be better understood if commercial were not seen as a black mark, as a mark disfavoring fair use, but what you have is a kind of a spectrum from the ultra commercial down to ultra social benefit, not for profit thing. And where is the neutral point? The neutral point should not be below simply commercial, in the sense that the artist was engaged in a remunerative occupation, like Two Live Crew was performing its music for money. I mean, the whole purpose of copyright is that artists can earn a living from being artists, and creators can earn a living from creating. And it seems to me that there is this supra-commercial, advertising. I can see advertising is on the negative side of the balance. But I think the neutral point should not be that everything that is on the commercial side is a negative, and in order to go below the neutral point, you have to be into doing it for free, for not for profit, social benefit kinds of things. But maybe the simple fact that the thing is being done for money and profit is not a negative. It's only if it goes into supra-commercial, like advertising, that it becomes a negative factor.
Before we close, I'm going to use moderator's prerogative to allow one more question. Ed Claris.
Oh, thank you. I wanted to ask a question about the transformative use versus the work that's transformative, and ask you whether the Warhol decision sheds light on the Google Books decision in terms of how we think about the output of what Google Books was doing, which was a search result, and whether we need to apply that new way of looking at transformativeness to situations that may come up in the AI cases or otherwise.
As I said earlier, one of the questions that arose in the Google Books case was the n-gram function, which I spoke about, and the n-gram function was one that did not, where the use, the copying use, was not for the purpose of shedding light on the particular text that was taken, but it was nonetheless found to be a fair use. That was the secondary use. And now, I'm not sure that it was necessary to reach that at all in view of the fact that the taking was already justified by the first use, which was to permit users of the Google Books website to get information about the particular book that had been copied. But I think that illustrated by a holding, or perhaps a dictum if it was deemed unnecessary, of a court that there could be uses that would be fair uses without commenting on. But in this particular context of feeding all the data into the computer for the purpose of producing these studies that didn't reflect directly on the work being copied. But otherwise, I maybe if I had a week to think about it, I'd think of more to say.
I take it that one of the implications of Ed's question is if you're looking use by use, right, the use about, where the output is about the copied work, that's fair use. But then there are these other uses that maybe they should or shouldn't be bootstrapped to the about use. So there's the n-gram use, and then there's other internal uses of the data that Google makes without any output. So, and Pam was talking about this last night. So Google Translate is immensely benefited by that huge database that was created by the books, by copying all those books. Now, these haven't been litigated, and I don't want to ask any questions that would get the panel into prejudging what may well come before it. But I take it that that's lurking behind your question, just because one use has been found to be fair. What about the other uses that all derive from the common nexus of operative fact? So I guess we'll have to stay tuned on that. All right. So Pippa, do you want to? Yeah. Do you want to close us up?
So I want to thank everybody for coming today, for your participation and attention. We've had such dynamic speakers and so much wonderful information shared. So thank you. We hope you found it as rewarding as we did. And we will host you all upstairs on the 7th floor for a reception. It is well labeled. Just take the elevators up to 7 and
to reception? I'll see you there. This will go by John Ford.